based on the unequivocal message demonstrated by the flag with the peace sign. But in this case, Your Honors, that is certainly not the scenario, because green hair and coins in such a hair, or as the record states, quote-unquote bling, can mean a variety of different things. In the case at bar, the Tesla School District has clearly perceived it rationally under Morse versus Frederick as denoting illicit drug sale. Now, in this case, Your Honors, it's important again to look at, notwithstanding the symbolic speech issue, whether Ms. Carter's hairstyle was protected speech under the First Amendment. Now, although Tinker versus Des Moines Independent Community School District establishes that students do not shed their constitutional rights to free expression at the schoolhouse gate, it states that these rights must be applied, quote, in light of the special characteristics of the school environment. And according to Spence versus Washington itself, if a protest is on private property, it necessarily accrues more protection than that which is in instances or environments where the state, by necessity, has to have greater supervisory regulations over such speech. So if this court grants the notion that this was symbolic speech, it is still permissibly regulated because Ms. Carter's hair posed a material and substantial disruption. Now, according to Tinker once more, which cites Burnside versus Byers in its conclusion, it's important to examine the criteria for material and substantial disruption. According to Burnside and Tinker concomitantly, a material and substantial distraction, if you will, is something that provides a specific impediment to the school environment in that it stops school functions from occurring. Now, in the case at bar, Your Honors, this is exactly what happened. Mr. Mansfield was administering the instructions for the exam. The student interfered with the ability of the other students to pay attention, as well as conduct the exam, demonstrating that there was a material and substantial disruption.
Is that Ms. Carter's fault? I mean, why would it be Ms. Carter's fault? You have somebody playing with her hair. Wouldn't the natural thing be for the teacher to look at the person who was playing with the hair and say, sit down?
Your Honor, perhaps different disciplinary measures against that particular student could have been taken. But the issue is, again, the fact that Ms. Carter facilitated this practice.
By having hair?
By having hair that posed an inherent distraction. Again, the fact that it facilitated this and she personally had a problem with the student playing with her hair. This makes her a party to the distraction, Your Honor.
You know, the issues that you raise do seem to me to be the kind of issues that jurors routinely decide.
Well, Your Honors, in this case, pursuant to Rule 56 of the Federal Rules of Civil Procedure, summary judgment was correctly granted without the jury trial because there exists no genuine issue of material fact. Now, according to Hunt versus Cromartie, a mere alleged factual dispute between parties does not necessarily constitute a genuine issue over the fact. So in this case, the parties do dispute why Ms. Carter dyed her hair in this way, and they dispute a few other things. But this demonstrates the ambivalence of Ms. Carter and what her hairstyle actually symbolizes. It demonstrates that she's no intent to convey a particularized message, nor possesses such a message to begin. Now, Your Honor,
can I go back to your disruption argument? The record doesn't seem to establish that this was anything more than a momentary thing. We seem to have gone from 0 to 100 miles an hour here in no time. Shouldn't Mr. Mansfield have tried to say, quiet down or pay attention, or you're distracting me from giving out the test instructions before Ms. Carter suddenly found herself expelled for something she didn't really do?
Well, no, Your Honor, in this case, because it was a perpetual threat to the school environment that couldn't simply be eliminated. Now, the fact is that
it was a perpetual threat. How come it went on for 20 months without any action by the school?
Well, Your Honor, over this duration, the interim that you speak of, there was an accrual of the facts relating to Ms. Carter's distraction problem. No less than 2 teachers 6 months prior to the incident reported having found major distractions to them and other students in Ms. Carter's hair. Additionally, there were burgeoning signs of drug use in the school environment at Tesla High School.
Well, let's take the first part first. Shouldn't the school have to have said something to Ms. Carter? 2 teachers have come to the principal and complained that your hair is causing a disruption. We want to put you on notice that you need to do something about your hair because you're in danger of violating the Tinker standard.
Well, yes, Your Honor, this did occur, in fact, in the school hearing and also with Ms. Carter, or excuse me, Ms. Blake. Ms. Blake gave Ms. Carter the option of either desisting from practice or facing disciplinary measures. So in this case, Your Honor,
but not in any of the earlier episodes. Ms. Carter was, as far as the record seems to
certainly may be the case, Your Honor, but it has really no bearing on the fact that it was a legitimate action on the part of the Tesla School District in curtailing the speech in some manner, shape, or form. Now, applying the United States versus O'Brien's test here, we can see that if we grant this as symbolic speech, incidental limitations on the non-speech aspect, that is, the distraction of the student specifically playing with the hair in this case, can justify incidental regulations and limitations on the speech aspect. Thus, again consistent with the rule established in Tinker, which constitutes the bulwark of free speech rights against governmental imposition, the Tesla School District was correct in essentially regulating the speech because it provided that material and substantial disruption. Now, unlike the facts of Tinker, which aren't comparable necessarily to the instant case, the Tesla School District didn't have any account of scientific or malice in regulating Ms. Carter's hairstyle. This is because they did not perceive the message involved. Now, in Tinker, there was a distinction.
What do you mean they didn't perceive the message involved?
Excuse me, Your Honor, they didn't perceive the message that she purportedly states.
But didn't the school district interpret it as some sort of pro-drug message, and isn't that really why the school is upset about the hairstyle? I'm just concerned about the fairness to the student if there's no fact that shows that she was involved in drug activity or meant to promote drug activity. The real reason the school was upset is because they think that's what was going on.
Well, Your Honor, the record indicates that this certainly was the case, that Ms. Carter denies having sold drugs, but under Morse versus Frederick, it is permissible and certainly encouraged for students, for principals and other school administrators to take actions on reasonable inferences of drug sale. Now, in the Morse case, there was a banner that...
On the record though, that I read, there was no indication that she was actually selling drugs.
Well, Your Honor, the nexus between these two was a part of the inference, but again, this was valid. Now, it is established in the record that in the Tesla High School, wearing green in the usual spots such as in hair or on a hat, and incorporating quote-unquote bling in such a hair, is denotative of oneself.
That's what the principal said about 3 years before this, isn't it?
Yes,
From
Your Honor.
April 2007 to September 2009, what happened in between? Did the principal suddenly decided that the green hair that this student has had for months is suddenly a sign of drug involvement?
Would Your Honor like me to briefly conclude?
Time, I see. Yes.
Your Honor, in response to that question, again, it demonstrates the accrual or compounding of the disciplinary problem. The reason the Tesla School District didn't apprehend Ms. Carter at that point was simply because Ms. Carter was a good student academically. But again, when there's the drug issue, when there's the issue of the fact that there's the increase in distraction, the Tesla School District was certainly justifiable and permissible in promoting the educational environment through this action. The aforementioned reasons, we strongly urge the court to overturn the holding of the U.S. Court of Appeals. Thank you.
Madam Chief Justice, and may it please the court, I am Hannah Clark, and I represent Ms. Zoe Carter, the respondent in this proceeding. This court should affirm the Court of Appeals reversal of the district court and remand the case to the district court for a trial on the merits. It should do so for the following reasons. First, summary judgment is not appropriate in this case because there are genuine issues of material fact which are up for interpretation, specifically the meaning and political nature of Ms. Carter's hair as symbolic speech, which is protected by the First Amendment. Second, the district court misused summary judgment by not considering evidence in the light most favorable to the non-moving party, in this case, Ms. Carter. First, summary judgment is not appropriate. The applicable legal standard is Hunt v. Cromartie, which stated that summary judgment is not appropriate when there is any evidence open to multiple interpretations that is a genuine issue of material fact. There are two issues of material fact in this case. Issue 1, the message conveyed by Ms. Carter's style and color of hair. Ms. Carter in 2007 dyed her hair green, the color of month. In December of 2007, she put points in her hair. From 2007 to the present, she's grown her hair out, all as part of a symbolic protest against excessive federal government spending, specifically that of the Bush administration.
But counsel, there doesn't seem to be anybody in the record who knows that this is a protest besides Ms. Carter?
Yes, Your Honor, that actually brings us to the second issue of material fact, which is whether or not her message was understood by others. Now, Ms. Carter claimed that there was another student at Tesla High School, Ms. Jo Lupo, who adopted the same hairstyle, ostensibly for the same reasons, after talking to Ms. Carter. The record states that Ms. Carter claimed that there are, in fact, other students whom she told her hairstyle about, but since summary judgment was granted, these witnesses were not able to stand trial, and we are therefore unable to determine the validity as to whether or not these witnesses existed and understood the meaning behind Ms. Carter's hair. These are both issues of material facts because they are key to access the Spence versus Washington two-factor test for what constitutes symbolic speech. First, does it contain a particularized message, in this case that of being against excessive federal government spending? And second, is there a high likelihood that others, in this case others in the school, understood that message?
You know of any cases where just the style of one's hair has been considered as symbolic speech purposes?
No, Your Honor, there are multiple courts of appeals cases, including Jackson v. Dorier, Green v. Bush, etc., in which there was government regulation of student hairstyle was upheld, that none of those hairstyles had any sort of political meaning, and none of the students in those cases contended that there was political meaning. Political meaning behind the hairstyle is what separates this case from all the other court of appeals cases.
But what assurance is there for us that under Spence that Ms. Carter didn't think of this explanation about the protest when she was on her way to the principal's office or when she was on her way to the courthouse?
Yes, Your Honor. When Ms. Carter was first brought to the principal, she said, quote, "It's within my rights." Now, that statement does not preclude the possibility that the rights she was talking about were those